This video reviews the core concepts, principles, and challenges related to the exercise of jurisdiction by states in international law, highlighting key themes such as sovereignty, territoriality, extraterritoriality, and the evolving role of international cooperation and reasonableness. 1. The nature of jurisdiction, sovereignty, delimitation, and the Westphalian Order. Jurisdiction in international law is fundamentally linked to the concept of state sovereignty. It represents a state's right to prescribe and enforce laws and is an essential component of statehood. Sovereignty both enables the exercise of jurisdiction and acts as a restraining device by informing international rules that limit such exercise. In essence, the laws of jurisdiction delimit the competences between states, serving as the basic traffic rules of the international legal order. Historically, jurisdiction has been strongly anchored in the territorial dimension of sovereignty, reflecting the persistent Westphalian bent of the international legal order. This means that actions within a state's territory are generally lawful, while assertions pertaining to acts outside its territory are suspect and even presumptively unlawful. This emphasis on territoriality emerged in the 17th century with the centralization of state power and advancements in cartography. While community-based conceptions of jurisdiction have been proposed, especially in the context of global communication and the Internet, states continue to view territoriality as the most straightforward and certain way of delimiting competences between them. Traditionally, international law of jurisdiction has been negative obligations to defend state sovereignty and prevent intervention in other states' affairs. However, there's a growing positive dimension, reflecting an evolution towards a law of cooperation. This implies states may be obliged to exercise jurisdiction, particularly for grave crimes such as war crimes, torture, terrorism under acte de dire adjudicaire clauses, or under human rights treaties requiring states to secure the rights to individuals falling within their jurisdiction, even if these individuals find themselves outside their territory. 2 forms of jurisdiction: prescriptive, enforcement, adjudicatory, and functional. Prescriptive jurisdiction is the power of a state to make its law applicable to the activities, relations, or status of persons, or the interests of persons in things. While the 1927 Lotus case suggested states are free to exercise prescriptive jurisdiction unless a prohibitive rule exists, the international community has largely adopted a more restrictive approach requiring a state to rely on a permissive principle for lawful exercise. Territoriality principle is the most uncontested principle. Acts within a state's territory fall under its jurisdiction. This can be complex, especially with transboundary crime. Subjective territoriality refers to where an act is initiated, and objective territoriality to where it is completed or causes effects. In criminal law, jurisdiction is often asserted if one constitutive element of the crime has taken place in its territory. However, in deterritorialized areas like cyberspace, this becomes challenging and can lead to jurisdictional conflict and even human rights concerns regarding unexpected subjection to foreign laws. An application of objective territoriality, notably in competition law, where foreign anti-competitive practices are subject to a state's jurisdiction if they cause effects within its territory. This has led to international tension and blocking laws by foreign nations. Apart from territoriality, the law of prescriptive jurisdiction features a number of principles that allow states to exercise jurisdiction on an extraterritorial basis, especially in the criminal law. These principles are usually premised on a link with the asserting state, notably nationality, or political independence. The universality principle, in contrast, premises jurisdiction on the nature of the crime rather than on a particular nexus with a state. Although in practice universal jurisdiction is often only exercised when the alleged perpetrator is present on the state's territory. Enforcement jurisdiction refers to a state's power to enforce or compel compliance or to punish non-compliance with its laws or regulations. This is much stricter than prescriptive jurisdiction. States are generally not entitled to enforce laws outside their territory without a permissive international rule. Enforcement must typically occur through territorial measures. Extraterritorial enforcement measures usually elicit strong international protest. The legality of remote technological searches on foreign computer networks without consent or mutual assistance remains unsettled. Adjudicatory jurisdiction refers to a state's power to subject persons or things to the process of its courts or administrative tribunals. This concerns the jurisdiction of courts and a defendant's expectation of being sued. Prescriptive and adjudicatory jurisdiction do not always coincide. Functional jurisdiction is mainly used in the law of the sea, referring to coastal states' limited jurisdiction over activities in their maritime zones and, to a limited extent, any state's jurisdiction over piracy and slave trade on the high seas. It involves both prescriptive and enforcement components, primarily to protect coastal states' interests and, exceptionally, common concerns. 3. Jurisdictional reasonableness and conflict mitigation. The existence of multiple permissive principles of prescriptive jurisdiction means that several states can often claim jurisdiction over the same situation, inevitably leading to international friction. International law currently lacks a clear rule to resolve such overlapping claims, for instance, by giving priority to the most interested or affected state. Though territorial states are often seen as having the first right-of-way, the difficulty lies in defining which state is truly territorial in complex transnational scenarios. 4. Subsidiarity in the law of jurisdiction. Ringert proposes infusing the rule of reason with a subsidiarity dimension. This suggests that bystander states should generally refrain from exercising jurisdiction when another state is better placed to bring its laws to bear, based on its stronger contacts. However, this deference should not be unconditional. A bystander state could, and perhaps should, exercise subsidiary jurisdiction as a trustee of mankind if the more strongly connected state fails to genuinely investigate or prosecute or address a situation in a way that serves the global interest, especially in the absence of multilateral regulation. This dynamic is seen in international criminal law, mirroring the ICC's complementarity principle, where bystander states can act if the territorial or nationality state fails to genuinely investigate or prosecute. Several European countries apply subsidiarity either by law or as a discretionary doctrine in such cases. Subsidiarity plays a restraining role through domestic tort techniques like exhaustion of local remedies or forum non-convenience. Conversely, it can also expand jurisdiction through forum of necessity-based techniques, allowing states to exercise jurisdiction when justice demands, particularly when victims lack reasonable access to a territorial forum for grave violations. Subsidiarity can manifest as an economic principle that permits extraterritorial jurisdiction if it would increase global welfare, especially when states with stronger links condone or even encourage export cartels or corrupt practices. However, this approach can be controversial due to discrepancies in national economic laws. Ringert notes that states may extend their domestic regulation extraterritorially to level the international playing field and address global public goods when multilateral solutions fail. This territorial extension can be in tension with classic jurisdictional rules, but may be justified by finding a territorial nexus or by the failure of multilateral solutions. 5. Concluding observations. While multilateral agreements and centralized institutions would ideally resolve many jurisdictional problems, individual states will likely continue to play a leading role in global governance due to the elusiveness of relevant multilateral agreements. This unilateral exercise of jurisdiction, while potentially leading to abuse by powerful states and regulatory chaos, is expected to persist. Therefore, a rule of reason is crucial, requiring states to defer to those with a stronger regulatory interest. However, this deference should be conditional, depending on the ability and willingness of the most interested state to genuinely address the situation in ways that serve the interest of the international community. If this burden is not discharged, bystander states may legitimately exercise subsidiary jurisdiction.